This video is not legal advice. It is produced solely for research and educational purposes. AI is increasingly forming contracts on our behalf. Virtual assistants order products. AI tools analyze documents and propose contract terms, and in some cases, AI systems autonomously conclude sales contracts without direct human input. But what happens when AI makes a mistake? If an AI system agrees to a contract at an absurd price, should the person who deployed that system be bound by it? Today, we're looking at a 2025 article by Maarten Herbosch, published in Computer Law and Security Review, Volume 56. The article is titled, "To Err is Human: Managing the Risks of Contracting AI Systems." The article takes a comparative approach, examining American common law alongside Belgian, French, and German law. Herbosch identifies two prevailing views in the literature that he disagrees with. The first view holds that AI systems simply cannot form legally binding contracts because there is no human intent behind the AI's actions. Under this view, AI-formed contracts are invalid from the start. The second view accepts that AI can form contracts, but argues that the deployer, the person who uses the AI system, should bear all the risk. Since deployers knowingly use imperfect systems, they should not be allowed to escape contracts that turn out badly. This is based on the Latin principle, ius damnum, cuius commodum, meaning the loss should fall on the one who enjoys the benefit. Herbosch challenges both views. His central thesis is that existing contract law frameworks are flexible enough to accommodate AI systems, and that AI deployers are entitled to meaningful legal protection. Before diving into the legal analysis, Herbosch distinguishes two main ways AI systems are involved in contracting. First, AI-supported contracting. This is a human-in-the-loop setup where AI provides advice or analysis, and a human makes the final decision. For example, an AI system might assess whether a painting is authentic, and the human buyer relies on that assessment to make a purchase.
Second, AI-driven contracting.
Here, the AI system autonomously forms the contract. A well-known example is the case of a 7-year-old girl who used her family's Amazon Echo to order a dollhouse. The system completed the purchase without any human reviewing the specific transaction. Herbosch analyzes AI-supported contracting first to develop key insights about the mistake doctrine, and then extends those insights to the more challenging case of AI-driven contracting. This is where Herbosch makes his most distinctive theoretical contribution. He argues that intent in contract formation serves a dual purpose. The first function is what he calls a fundamental safeguard. A party must have had the possibility to withhold assent. In German law, this corresponds to the concept of Handlungswille, the intent to take any action at all. When someone deploys an AI system to form contracts, this first function is inherently satisfied by the act of deployment itself. The second function is more subtle. Intent serves as the object of the counterparty's perception. What matters is not the deployer's actual, subjective intent, but what the counterparty can reasonably believe the deployer intended based on the AI's output. In Herbosch's words, the actual intent is unimportant. Only the perceived intent matters. This means AI does not require any new theory of intent. Unlike scholars such as Eliza Mick, who proposed a theory of prior intent for AI contracting, Herbosch argues that the traditional framework already handles AI. The deployer's act of deployment satisfies the first function, and the second function operates identically whether an AI or a human generates the declaration. As Herbosch puts it, theories proposing to generalize intent overstate its role and imply a need for change that existing legal frameworks do not require. Building on this theory of intent, Herbosch proposes that AI deployers enjoy protection on two levels. The first layer concerns contract formation itself. If the counterparty cannot reasonably believe that the AI-generated statement reflects the deployer's intent, they cannot rely on it. This is essentially the too-good-to-be-true principle. If an AI system offers a product at 1% of its market value, the counterparty should investigate rather than rush to accept. Deployers can strengthen this protection through transparency, for instance by disclosing that the counterparty is interacting with an AI system, as required by the European AI Act. The second layer comes from the doctrine of unilateral mistake. Even after a contract is formed, the deployer may be able to rescind it if the requirements for unilateral mistake are met. To explain why the mistake doctrine applies to AI-formed contracts, Herbosch offers a significant reinterpretation of what the doctrine actually protects. He distinguishes two types of mistake. The first type is where a mistake motivated the decision to contract, for example buying a painting because you believed it was authentic when it was not. The second type is where a mistake pertains to the meaning or effects of the declaration itself, as in the famous British case Raffles versus Whitchelhouse, where both parties referred to a ship called Peerless, but each meant a different ship. Herbosch argues that because the mistake doctrine covers both types, it cannot be accurately described as protecting intent. Instead, he proposes that the doctrine protects the reasonable expectations of the mistaken party. This reframing is crucial for AI contexts, because it means the doctrine can apply even when the deployer had no specific intent regarding the particular contract, as long as the AI's output diverged from the deployer's reasonable expectations. He draws an analogy to clerical errors. When an AI system produces an erroneous output, the situation is analogous to a clerk who writes the wrong number. The resulting declaration diverges from what the party reasonably expected. The mistake doctrine, Herbosch argues, applies to the method by which a manifestation of intent is generated, and this naturally encompasses AI systems. Under American law, the unilateral mistake doctrine typically requires 5 conditions. Herbosch argues that the first 3, a basic assumption, material adverse effect, and unconscionability, do not present special challenges for AI. The real questions arise with the remaining 2. First, risk-bearing. Some argue that deploying an AI system means the deployer automatically assumes the risk of any errors. Herbosch rejects this blanket approach. He points out that all transactions involve uncertainty, whether AI is involved or not. The risk-bearing requirement should be reserved for cases where a party was consciously ignorant, and the more nuanced assessment of excusability should handle the rest. He also addresses the argument that AI contracts are inherently speculative, since AI systems operate on statistical correlations. Herbosch insists that this must be assessed from the deployer's perspective, not the AI system's. The fact that an AI uses probabilistic methods does not make the deployer's contracting decisions speculative. Second, excusability. This is the most significant requirement in AI contexts. Herbosch draws parallels with cases where humans rely on expert advisors. 2 factors are critical: how the deployer selected the AI system and how they treated its output. Deploying a high-performing system reflects diligence. If the AI outperforms human experts, relying on it may be even more diligent than relying on a human advisor. Using an explainable AI system adds another layer of diligence, though explainability is not always feasible or required. The deployer's expertise matters. An AI expert is held to a higher standard than a layperson. The significance of the contract also matters. More important contracts demand greater caution. And deployers should maintain records of system performance, accuracy, and parameters, as these could prove critical in establishing that their reliance on the system was reasonable. Herbosch emphasizes that it is the human deployer's excusability that must be evaluated, not the AI systems. This point directly challenges the approach taken in the Singaporean case Coin PT Ltd v B2C2 Ltd, where the court attributed the programmer's knowledge to the contracting party. Let me summarize Herbosch's main conclusions. First, contracts formed through AI systems are generally valid, even without explicit human intent for the specific transaction. Policy considerations and the way legal systems handle misunderstandings support this position. Second, AI deployers enjoy 2 layers of legal protection. The first layer filters out cases where the counterparty could not reasonably have relied on the AI's output. The second layer allows deployers to invoke the unilateral mistake doctrine under appropriate circumstances. Third, the requirements for unilateral mistake are not fundamentally altered by the use of AI. The exception is excusability, which requires careful, case-specific analysis of whether the deployer's reliance on the AI system was reasonable. Fourth, and most broadly, current contract law frameworks are flexible enough to accommodate AI systems. A complete overhaul of contract law is unnecessary. As industry standards develop, particularly under frameworks like the European AI Act, the boundaries of these protections will become clearer. In the meantime, Herbosch recommends that deployers focus on selecting high-performing systems, maintaining adequate records, and exercising oversight proportionate to the stakes involved. That's our overview of Maarten Herbosch's 2025 article, To Err is Human: Managing the Risks of Contracting AI Systems, published in Computer Law and Security Review, Volume 56. Thank you for watching.